Aaratrika?
Yes, sir. Hello and welcome to The Hindu. The 50th Chief Justice of India, Dr. D.Y. Chandrachud, retires on November 10th, leaving behind one of the most consequential legacies in the Supreme Court's history. Over 8 years as a Supreme Court judge and 2 years as the Chief Justice of India, he has delivered some of India's most landmark judgments. He has also initiated some much needed technological reforms in the Supreme Court. However, his tenure has not been free from criticism. Concerns have been raised over an alleged misuse of the master roster's powers, that is, the judicial discretion enjoyed by the Chief Justice to assign specific cases to certain judges, and also the weakening of the collegium's resistance to political influence. The question that we attempt to answer today is: does Chief Justice D.Y. Chandrachud leave the Supreme Court as an institution in a better place than where he found it? Joining us for a conversation on this is my colleague, Mr. Krishnadas Rajagopal, the Hindu's legal correspondent. Hello, sir. Welcome to the show.
Thank you, Aaratrika, for having me.
So, if you could begin a bit with the verdicts that he delivered during his tenure, a remarkable facet of his tenure was that he decided some long pending Constitution bench cases. He delivered close to 16 Constitution bench judgments, including on contentious issues like the constitutionality of the abrogation of Article 370 of the Constitution, as well as the electoral bond scheme. So, if we could make a note of, let's say, three, four important verdicts and the potential implications, what would they be?
I think his judicial repertoire, or the number of judgments that he wrote, and the number of benches that he was part of, both as a puisne judge and the Chief Justice of India, is huge. It's phenomenal. But if you tell me to pick a few judgments, it would be the abrogation of Article 370, the verdict, which said that the special privileges under Article 35A were only a feature of asymmetric federalism and not sovereignty. And where the court said that you have to conduct elections in September, which happened, which was the impact of the judgment. And now the restoration, the court said you have to restore statehood, which is now in the process. But at the same time, the judgment is also problematic in the sense that its silence is also ominous. It's pretty silent about the circumstances which led to the abrogation, the reorganization of a state, full-fledged state into two union territories. It does not address the issue whether the president's rule, the dissolution of the legislature, and the detention of the leaders were necessary. So that is on these aspects, the verdict is quite silent. And then, if you take it, because his span of work touches on every aspect. One is this abrogation. The other is the electoral bonds case, where they bell the cat on the fact that the electoral bonds case is not just, as the government said, to curb black money, but it is actually a culture of quid pro quo. If you scratch my back, I'll scratch your back. That the court said so in so many terms, words. And they also said that the contributions were not an exercise of the right to political belief of people, but it was just payment for favors.
Correct.
But yes, so and the court did not also agree to the fact that the election bond scheme was a reasonable restriction to the voters' right to information. So that's the second one. And then the marriage, the same-sex marriage equality, the verdict, where Chief Justice Chandrachud found himself in the minority. Justice Ravindra Bhatt had the majority judgment. But having said so, the judgment also brings out the fact that even after 5 years of decriminalizing homosexuality, the government of the day finds atypical gender identity and sexual orientation still an elitist concept, because that was what the government argued. There was something alien about this group of people. Um, and the Constitution bench's comments highlighted social and even state discrimination on the basis of sexual orientation. And then I think the subclassification of quotas, where the Supreme Court upheld the state's right to subclassify quotas, subclassify scheduled castes for quota benefits. Where, interestingly, it stretched the point by saying that the creamy layer principle should extend to scheduled castes and scheduled tribes, and not just the other backward classes. And in fact, there is a direction that the government should actively consider, expanding the creamy layer of it. And then finally, of course, it's an open and shut case. Sukanya Shanta's petition on caste-based discrimination in prisons. I have to say that the authorities were caught napping in this case, and we saw the Chief Justice personally acknowledge Sukanya, the journalist's contribution to this fact. And at 75 years after the independence, we were still following the colonial laws within the state, within the prison walls, and there was division of labor, manual labor according to caste division, and even sleeping quarters were divided or distributed according to the castes. So this was a basic judgment which looked at the basic rights of a human being and found that a convict or an under trial, even if he goes inside prison, even if he's a convict, even if especially if he's an under trial, is still a human being and also a holder of all the rights that the Constitution guarantees him. So I think these are the four or five judgments that's really made a mark.
If I can also take you back to actually the Article 370 verdict, I think one of the most prominent criticism was the fact that the court refused to assess whether it was constitutional for the conversion of Jammu and Kashmir statehood to be converted into union territory on the mere assurance of the union government that sometime in the indefinite future they
Yes.
would actually restore the statehood. So I think that is something. Yes.
In fact, the hearings, he had asked these questions whether whether did you follow the proviso of Article 3. Which means that you have to consult the state legislature if you want to make any changes in the topography or the whether you want to make any changes in the state. And Chief Justice had these pointed questions asked. And it also, when the Solicitor General, when the Centre said that the Parliament took on the responsibility of the state legislature, so the court basically asked the Centre whether now you make your law and you pass it. And where is the consultation? Where is the point of federalism, as you say, included in this whole exercise? So, but these are not actually reflected in the judgment. The circumstances which led, the court basically says that we don't want to question what the president had in mind or the president's considerations while going for the. This was a chance. This was an opportunity to make a certain jurisprudence, because this can. The government assures that this will not be the case, but this can. There's a possibility that this can happen in the future of a country again.
Right. So a lot has also been said about how the Chief Justice has exercised his suo motu jurisdiction, the court's suo motu jurisdiction, so to speak. What experts have flagged is that there has been a lack of consistency and a lot of dichotomy in terms of the cases which the court took suo motu cognizance of. Uh, Experts have said that there were cases which were very political in nature, which the court took suo motu cognizance of with no foreseeable legal outcome. For instance, the Aaratrika rape and murder case, where we've seen that the investigation was already transferred to the CBI by the High Court, and the High Court was already cognizant of the matter. But despite it, the Chief Justice took suo motu cognizance of it. So do you think that, maybe the Supreme Court should lay down some sort of standard? Otherwise, there's a lot of question regarding this judicial discretion exercised.
Well, there is an Article 142 in the Constitution which says that the court can deliver substantial justice, substantive justice. But I think, as you say, if you are taking suo motu cognizance of an issue, you have to do it in open court, and you have to give the reasons for taking suo motu cognizance. Because we are having, or there is a public opinion, there is an opinion that questions the motives of court. Why are you taking this? Do you have a political motive? Do you have some other ulterior motive for this? This can be addressed by giving out in black and white the reasons that we are, for example, as you said, RG Core, though the High Court had transferred it to the CBI and was cognizant of the matter, the Chief Justice made it clear that listen, we are taking this because we are looking at the larger perspective of women's safety, of medical professional safety and security across the country, and there has to be a national protocol. So when you give reasons, then the public skepticism comes down, and then you can go forward and make a good law, because there
Right.
is you are the top court in the country, and you can give an authoritative pronouncement which spreads across the country. You have the powers that the High Court probably doesn't have across the country. I mean, there's your court of record. I think the fact here is that at one point you have to put it out in pen and paper and say that, listen, I'm taking suo motu cognizance for this and this reason, because this is a larger issue, and the court, it's not the judge taking suo motu cognizance, it's the Supreme Court taking suo motu cognizance, and we need to have a uniform national law addressing this problem.
Right.
uh, but we've had the court has an history of, if you remember, Justice Ranjan Gogoi suddenly taking suo motu cognizance and sitting on his own bench in his own case on a Saturday. So these are the instances that actually have planted the seed of doubt and skepticism in the public.
And of course, I'm sorry to interrupt, but again, when the order was uploaded, his name was nowhere there
His name
as
was not there, exactly. And it was Justice Sanjeev Khanna on the bench
yes,
also.
he was also part of the bench. Yes.
Yeah.
Uh, so I
So
think
I
I
think,
think another instance that also comes to mind is the fact that the Supreme Court took suo motu cognizance of the entire Adani Hindenburg issue, but for instance did not take cognizance of the petition for which questioned the arms transfer to Israel. I think that was a very well drafted petition which was grounded on India's obligations under international law. So,
hmm.
like you said, that there's a lot of dichotomy here, which of course is very suspect. So, I mean, I'm guessing if the guidelines or a national law to this effect would kind of assuage concerns.
But yeah, when you look at guidelines, it should not limit the court, because there may be instances. You may know the demolitions case. The case is already there. It's not a suo motu, but I'm saying it's happening across multiple states. So at least the court should take in suo motu if it had not been I mean, any hypothetical case, and the court can make a general inquiry into what is happening. Uh, because it is also the sentinel on the alert, the sentinel kiviva it is not there just to pass laws or pass to pronounce judgments, but also to protect civil rights, the rights of the people. So if the court feels that within the constitutional limitation it can take in so more to certain cases, certain issues, then it should, because that is what makes the Supreme Court unique in the world,
Right,
the
right.
PIL jurisdiction.
And I think another important thing to
People's court.
highlight another important thing to highlight is also the fact that when a court takes suo motu cognizance, it is not just an academic exercise. There are practical consequences. It preempts the political process. For example, we saw in the Adani Hindenburg issue, because the matter is now sub judice, we have seen joint parliamentary committees refusing to scrutinize the issue because on the ground that the matter is sub judice now. So there's it leaves political power unaccountable. So I think that is also very, very important, which is why it has suo motu jurisdiction should be exercised very judiciously.
Judiciously. Yes, yes, you're right.
Another important facet, and of course, that's something that has been subjected to immense criticism, was Chief Justice D.Y. Chandrachud's exercise of power as the master of the roster. For our viewers who are not aware, the Chief Justice has the judicial discretion to assign specific cases to certain judges. Now, we saw during his tenure certain politically sensitive cases being listed before judges who were more inclined to favor the union government. That brings to mind the case of former JNU scholar Umar Khalid. We saw that he ultimately withdrew his bail petition from the Supreme Court to try his luck in the lower courts. What do you make of this? Do you think it's a fair criticism?
See, the listing and the master of roster, the allocation of cases is a huge issue, and it's a niggling issue. And I think it came to fore in the master of roster. The term itself came to fore in the press meet of the senior judges. That's the first time many people learned that this is the case, and it has continued despite all the achievements of Chief Justice Chandrachud. This issue is still continuing. The fact that we are still discussing it shows that the issue is still alive. Uh, I think there should be certain objective standards, that there should be transparency, because the Supreme Court is not just about protecting transparency but also practicing transparency. So
Right.
let's practice transparency. There was a petition, if you remember, by a senior advocate, Shanti Bhushan, where he said that the allocation of cases should be discussed. It should be a consultative process, like the collegium, the recommendation of appointments, like the appointments process. The allocation process should also be consultative. There should be a collegium, and it should be so that this skepticism is avoided. That make it transparent. So I think that will resolve the issue a lot, but the problem is still there. Now, in the case of, let's say in any bail case, if, for example, Umar Khalid, you have mentioned, Aaratrika, is a classic example where, his bail plea has been withdrawn. Uh, why has his bail plea been withdrawn? Now, there may be a judge uh, who may be ideologically in a certain beliefs. We cannot question that. That's a person's personal belief. And though a judge, the person is still a human being. Their social conditioning. Benjamin Cardoso says, the social conditioning never leaves the person. It continues, whatever role you play in life. But then we feel that the public feels that the judging, the reasoning in the judging, uh, when the judge reasons or uses the reasoning in the judging, is not sound. Is
Hmm.
is probably influenced by other by issues or by influences other than what is there in the law book. So
Right.
the judging is a very, I believe, a very formal, very scientific, and some people say very boring way of, deciding issues, disputes, where you follow the text of the law, whether it is in favor of someone or against someone. It's there out there in black and white. So if you follow that and if you give reasons and you use your reasoning powers, then and you show that you're using your reasoning powers, then the fact that a plea would not be withdrawn, that to a bail plea would not be withdrawn from the Supreme Court. So we can't blame anyone for having a particular ideology, but we can say that there may be a shortfall of public confidence, that maybe a perception is there in the public that judges are not using the formalistic tests and thresholds of law to say whether this case, whether a person wins a case or loses a case. So uh, I think that perception has to change.
I think a lot of anguish also stems from the fact that we have seen, at least when it comes to some of these cases, like whether it's Umar Khalid's bail plea or the Mahesh Raut's case, the Supreme Court has not followed the Supreme Court guidelines in the 2017 Handbook on Practice and Procedure, where the particular petition should remain either with the senior judge where it was first listed, or then go to a bench in case the judge is unavailable, go to a bench which is hearing similar matters. I think a lot of anguish also comes from that. And I feel what I really believe is that when you talk about UAPA cases, which is in itself such a draconian statute, and where you see bail hearings, they get converted into mini trials for that matter, because there's so much of judicial discretion that is exercised. And you take a call as to what extent do you scrutinize the center's submissions, the center's evidence. I think a lot of public anguish stems from the fact that if a certain bench is hearing a certain matter, then to what extent are other considerations at play when you exercise that form of that kind of discretion under these statutes?
Yes. And also, as a Chief Justice, you don't have to end up saying that you don't have to explain, justify yourself saying that I decided all the bail from A to Z, because if you follow a routine and if you follow the limitations, as you say, the handbook, then these are not necessary. These comments are not necessary. They can be avoided. You're in a high constitutional office. You don't end up saying all these things.
Right. Now, moving on to the topic of judicial appointments, out of the existing 33 judges at the Supreme Court, 17 had been appointed during the tenure of the Chief Justice. He also elevated Justice P.B. Varale, bringing the count of Dalit judges in the Supreme Court to 3. However, there has again been criticism on two accounts. First is that he did not elevate any woman judge to the Supreme Court. Of course, something that he defended later on, saying that he did not find anybody senior enough to be elevated. And the second, that he ceded more control of the judicial appointment process to the union government. There wasn't enough pushback from the collegium when the center was delaying clearing these recommendations. What do you think of this?
I think there have been certain obvious misses, yes. I think there was a very good opportunity when they were hearing the case on the judicial side, where, before Justice Sanjay Kishan called, and he was pulling up criticizing the government. Pulling up would be too strong. Criticizing the government on delay, and he just brought out every other facet of what's happening between the government, the traffic between the government and the collegium out there in the public in open court. And obviously the government was uncomfortable, but they had started making these appointments. Especially, they were at that point of time. There were, I think, a record number of acting chief justices in high courts, this was slow. The machine was slowly turning, but then at the end of the day, in December 2023, that's when he retired. Sorry, December 3rd, I believe, the case mysteriously vanished from his list. And he said in open court that some things are left best unsaid. So this showed a senior collegium member, the judge number 2 in the Supreme Court, venting his frustration. So obviously there was something wrong in the collegium, but now he's saying, now Chief Justice is saying that there was no rancor. We just shared snacks, and there was no personal agenda. Of course, there was no personal agenda. We're not talking about personal agenda, but we're talking about the obvious fact out there that there are vacancies and there are delays. There are people who've been waiting out there for months together. The people who've been recommended in 2017 and reiterated again, and they're still waiting. So what's happening? And also you have to see, Aaratrika, if you remember the judicial the memorandum of procedure for judicial appointments, that's still in a state of stasis. The government says that we've asked the collegium to make certain amends. The collegium said that our word is final. This is it. We don't want any further. It's stuck. It's stuck between them. So I think the NJAC decision was in 2015.
Right.
And we are in like 10 years, literally 10 years after that. So. And it was heard. The memorandum of procedure of appointments was heard by the Constitution Bench, by Justice Keher's bench, on what are the best points, and there were experts called in, and there was traffic. So this fact that it's all stuck there. There is delay. There is a lot of silence. The government can pick and choose candidates. Topple the seniority, despite collegium resolutions, where in one case, Justice Gauri's resolution, the collegium had specifically said that don't appoint this person before you appoint Justice Advocate Satyan. But
Clearance
what happened?
recommend. Exactly.
Yes, that's what
That,
happened. And then there was the case of Sarangi, Justice Sarangi, who had to wait for 6 months for his transfer to Jharkhand as Chief Justice, and he had just a 15-day tenure to in the Jharkhand High Court, and then as you know, Justice Murlidhar,
of course. Very
he
unfortunate.
was asked to go to Madras High Court. They recalled it when there was hardly 4 months left for him to retire. So, as Justice Call said in open court, I'm just quoting him, we're missing talent, missing huge talent. So, have solutions been found on the ground for these obvious mistakes?
Right.
I think
You
it's fake.
spoke about Justice Victoria Gauri's elevation. I think what is very important to discuss is also that her elevation to the Madras High Court was challenged by certain members of the Madras Bar Association. Now, after that, there were reports that she had allegedly made hate speech against communities. And when this particular challenge was mentioned before the Chief Justice early in the morning, the Chief Justice said that all of this came to our knowledge after we had already recommended, and that he would constitute a bench. But then, when the bench heard the challenge, that was Justices Sanjeev Khanna and P.R. Gawai, the bench said that all of this material the collegium must have already been cognizant of. So again, there's a dichotomy there as to what the Chief Justice says in open court and what the final order from this particular bench is.
Because I don't blame. In my opinion, I don't blame Justice Khanna's judgment, because there is no point going against the collegium. The collegium has decided, and I think he took a practical view of the fact that the swearing in was over by the time the hearing ended. If you remember, it was like the hearing was on, the swearing
Yes,
in was on. And by the
yes,
time the swearing in, by the time the hearing got over, the swearing in was over. So, and she's been, if you've noticed, she's been made permanent judge.
yeah.
I
It's a
mean,
permanent
see,
decision.
we are not talking about a personal on a personal level about Justice Gauri, because the collegium has an argument against this thing that an argument, the counter argument, which says that uh, what a lawyer says while he or she is a lawyer, we don't have to consider that the political ideology or what the lawyer says. We don't have to consider that when he becomes or she becomes a judge, which is what their reasoning is.
Right. What is the reasoning? And I think that we should also discuss the fact that the non-transfer of acting Chief Justice of the Madras High Court, then Justice T. Raja, who was
Raja.
actually there when the swearing-in ceremony was taking place of Justice Victoria Gauri, the center never cleared the recommendation to transfer him, and he actually retired from the Madras High Court. So, I mean, I think
And if I can interrupt you, and in his farewell speech, he said, "This is all being a judge is part of service, and if you are told to go, you have to go." This is what he said in his farewell speech while retiring as an acting chief justice from the Madras High Court.
the irony of it all. I think, but one good thing I feel, that is, of course, my opinion, a positive development has been that collegium resolutions have become more transparent and public. Detailed reasonings are given in these collegium resolutions. That is something that Chief Justice D.Y. Chandrachud started in his tenure. What do you feel about it? Do you think it's too much of information and sometimes might, let's say, harm the reputation of certain judges who are not recommended? Do you think that's too much of transparency?
See, the thing is that this, it all started with that press meet, and then it's after that that the collegium resolutions they brought in a slew of changes. One is, I think there was a computer allocation of cases, roster, this thing, and one of the changes brought in was this, that the collegium resolutions would be published and would be published in detail. So this was in the time of Chief Justice Deepak Mishra, and this tradition has followed, and Chief Justice Chandrachud inherited it. Of course, he
Hmm.
made it in certain occasions. He has made it very transparent, as in the case of the reiterations in January 2023 of John Satyan and Sakya Sen, and so. I think when it started out, they had started giving explicit reasons for why an advocate recommended for High Court justiceship or judgeship was rejected. And
Hmm.
then argument came out that, if you bring in all these details out in the public, then it will affect the reputation and the privacy of that man, and also affect his livelihood, because he has to go back. He is not appointed as a judge; he's rejected at some point, and he has to go back to practice. He has to go back to society and practice. So, and law, and as you know, a lawyer depends a lot on his reputation. And,
Of course, the goodwill.
the goodwill, yeah, exactly. So that may suffer a dent. So I think they tempered it, and they started. They slowly. They said these people have to be reconsidered, while they gave a detailed reason. They gave detailed reasons of why certain people have been recommended.
Hmm.
So, and this has continued. But I think an exception would be in the case, as you said, the transparency. And what was striking was this January 2023 resolutions, reiterations, where Chief Justice Chandrachud, these resolutions had uh, given reasons why the government objected to the recommendations of the collegium in the case
Right.
of Kripal, where they said that, because of certain his alliance, his partner, and that was the first time that the court basically, the collegium basically said that these are the reasons why the government is rejecting these people, and this is our answer to, and they answered it on constitutional terms. Uh, because the right to a person's sexual orientation and gender. So that was quite interesting to watch. How, there have been spells of, they've stretched transparency, and they've used it for the benefit of,
Right.
bringing the sunlight into the collegium process.
We'll have to see now what happens under
Yeah,
Justice tenure, of course. That'll be very interesting.
he
Uh,
has two. He has two immediately. He has two vacancies,
right, right.
and we'll have to see whether he will replace Justice Hima Kohli with another woman judge.
Yes, that's very
That is
interesting.
so. Yeah, and if that is so, then he will counter Chief Justice Chandrachud's remark that I didn't find anyone senior enough, any woman senior enough to be brought into the Supreme Court. Well, here
Right.
you are.
Right, right. I think he will have to appoint four judges because you have two judges retiring in January as well. So it'll be interesting to see the recommendations. Moving on to the host of administrative reforms that Chief Justice D.Y. Chandrachud brought in during his tenure. Some remarkable work done. For instance, he has institutionalized virtual courts that has really helped legal journalists like us to log into court, and of course, increase the accessibility of courtroom proceedings. Courts are not functioning in silos anymore. It's more accountable to the general public. We have live streaming of important proceedings taking place as well. What do you think are some of the other reforms that you think were, I think, remarkable in his tenure?
I think, as you say, live streaming, and during the COVID period, we had a struggle during the COVID period, and we were journalists, and we had to find some, because the courts were closed and the judges were at home. Some of them had COVID, and so the court, we consulted the Secretary General, and it was not Chief Justice. Justice Chandrachud was not Chief Justice. It was Justice Bob Day who was Chief Justice. So they opened a small room in the annex, and they had these old desktop. They had 4 or 5 desktops where they took a Wi-Fi connection, and then they showed the court proceedings, and we would all sit around it. Around a TV, like the olden times when your neighbor, the only one house would have a TV in the whole street, and everybody would come rushing in if there's a cricket match. So we would all come there and sit in a semicircle and watch. So from there, it has come to where you have the Supreme Court website has a what do you call it, the virtual link, and they are recently experimented with live streaming. So I think, as far as a journalist is concerned, from my point of view, that has been a remarkable change where we didn't expect this thing to happen, because the Swapnil Tripathi was there, but then he dusted it out and he made it out into something else altogether. So access to justice for all, including journalists, I should say. Quite
Yes,
good.
and I mean, not just for journalists. I also think when you look at some of the measures for litigants and lawyers, like we were discussing, I think before this discussion, that written submissions were being asked to file online. We saw a lot of senior advocates struggle with it also. For example, during the Article 370 hearings, and of course the overhaul of the mentioning system. The fact that a good 30 to 40 minutes before the start of each day used to go into this mentioning, and now of course it's just an email that you have to send to the registry. So that has really saved judicial time as well. And I think something else that we must highlight is the handbook on combating gender stereotypes that the Chief Justice came out with,
Yes.
and there was a
Yes.
panel of judges formed who drafted this particular handbook, so that there is no gender stereotypical language in court documents. So I think a lot of very very good measures by the chief during his tenure. Uh,
Yes.
Before we proceed to the last segment of this particular discussion, I would just like to tell our viewers that we will be opening the floor for questions. So after we're done discussing the last segment, we have our colleagues in the back room who are going to give us the questions. So if you have any questions, please feel free to let us know. I would like to kind of end this discussion with the 2 recent controversies which the Chief Justice found himself embroiled in. There were a lot of comments passed by various stakeholders. First is, of course, the Prime Minister being invited to his official residence, and of course, to observe the Ganesh Puja, and the Prime Minister was in a typical Maharashtrian attire and in complete public glare. And of course, the second is that when he was addressing residents of his native village back in Pune, he remarked that he had prayed to God for a solution while adjudicating the Ram Janmabhoomi dispute. Now, critics have said that that is unwarranted indiscretion, because in that particular dispute, the God, so to speak, was a juristic person. So, what do you make of these controversies?
I think, if you remember the reinstatement of judicial values cleared by the full court in the 1990s. I don't know. I don't remember which year. I think it was 91, or
If I'm
96.
yeah, I'm guessing yes.
So where they say that, where they the full court recognizes public perception as a factor in a judge's life, where they say that people should not perceive you as being mixing too freely. And you, in the sense, the judge. So there is. It's not the fact that there aren't guidelines covering that about your social life of a judge. At the same time, the judge is not supposed to be in an ivory tower. He has to interact, but he has to interact officially. On the second, and also I remember Chief Justice M.N. Venkatachalayya's he put it very succinctly of the judiciary executive relationship, how it should be. He said it should be correct, but not cordial. Now, on the second factor of what his comments about the Ram Janmabhoomi Babri Masjid dispute, I think he was addressing a certain audience
Correct.
about that. And I think it also indicates that he wants to bring out the fact that, indicate that he may be the author of the judgment because the judgment was unnamed. But as a judge, you apply to reason, not to faith. You are in that office. You are doing the judgment. You have been entrusted the task of hearing and writing the judgment under the Constitution. And the Constitution, as Chief Justice Chandrachud often said, is the judge's mantra. So I think that's could have been avoided. Such a careful man, shrewd, erudite. Wonder why he said that. It's puzzling.
Right, well put. And of course, he defended his conduct later on, saying that, when you have members from the executive and the judiciary meeting, it is just a social interaction. There are no deals cut, so to speak, and that judges are matured enough. But that brings to the question as to, are all judges matured enough to keep both separate during such interactions?
Exactly.
Um,
If you have the
so,
Chief Justice, he is mature. He's a man with a global view. He's done so much. But yes, as you say, I'm sure the members of the judiciary are mature. But then at the end of the day, it's public perception, and you have the social media at you, and you do this. It's kind of puzzling.
right. That brings us to the end of this discussion. Thank you so much, sir, for your insights. We'll have to, of course, all eyes will now be on Justice Sanjeev Khanna. We'll have to wait and see. Of course, he has a relatively shorter tenure, just 6 months, but hopefully it'll
But
be something.
if you remember, Justice UU Lalit had hardly 70 days,
Yes, yes.
and he put in motion a whole lot of constitution benches, and he delegated benches. They were hearing constitution benches in the morning, issues in the morning, and then he would come back to a regular bench and hear the day's board. So
A
tenure
lot,
of
of course, of course. We are opening the floor for some questions. Just 1 second. Let me see whether we have some questions for us. So, one question is, how do you see the balance between judicial independence and executive influence evolving in light of recent controversies around the collegium system and delayed appointments?
I think it's the judiciary is not just about balance. It's not just about, because balance is status quo. If you need to change something, you need to change. You need to change for the better. Merely sticking at balance is not enough. You have to go forward. You have to at times confront, and you have the power and the duty to confront. And come what may, you know, within the limits of the Constitution. So I think that the Supreme Court has to remember, in my opinion. So it's not just about balance; it has to go beyond that.
Right. We have another question from Tayab Hussain, who says, do you think Justice Chandrachud's legacy will impact what is to be expected from Justice Sanjeev Khanna's tenure?
Chief Justice Chandrachud said something very interesting yesterday. I mean, with all the publicity and the cameras on him, he said the Supreme Court is not a Chief Justice-centric court. That needs to reform. So we are talking about an institution. We're not talking about just Chief Justices. This is not the U.S. Supreme Court where there are 9, as Jeffrey Toobin said, 9 scorpions. we are talking about a court, an institution. So the institution has to be systemic. The changes that he's brought in, good or bad, the bad has to bail out, while the good has to continue or even augment it. So it's not just about Chief Justice Chandrachud or Chief Justice right now. Currently, he's designated Chief Justice. Let's say Chief Justice Sanjeev Khanna. It's about the institution, and the institution is more than 2 judges. So,
Absolutely.
So I
And I
think,
also feel
sorry.
so I also feel that now, because of the transparency in how the court functions, there's so much of public scrutiny, which I'm sure judges are also well aware of. So I think, whether it's the next Chief Justice or the judges in the future, they will be aware that they're being watched, and every single conduct of them will be dissected. So that will, I'm sure, will play a role.
And they have to welcome it in a certain manner.
The next question is from Devinder, who says, "What is your opinion, ma'am? What is your opinion about replacing collegium style with other system alternative?" Well, I don't really believe that the collegium system should be revoked. I think uh, it has a fine balance between making sure the executive has some sort of a say, and of course the collegium and the judges, the 3 senior most judges, have a say as well. I think what the problem is that the collegium has to kind of push back and make sure the center, there is no executive veto, so to speak. They have to make sure that the executive clears the appointments. So I don't think there should be, the system itself should be revoked. I just feel the collegium should take a stronger stance and make sure that there is no pendency in clearing the names by the center, even if it is distasteful, some of the names for the center.
And it's the best system we have now. And as of now, it's the law.
Right.
For good or bad.
Right. Are there more questions? I think, that's all for now. Thank you so much to all our viewers for tuning in. My colleague here has also written an excellent profile of the CJI designate Justice Sanjeev Khanna, so please make sure to read it. We will attach the link in the description box. Thank you so much, sir, again for joining us.
Thank you, Aaratrika. It was a pleasure talking to you.
Thank you.
Bye.
Thank you.
Bye.